Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is Thinking About Going Small? Starting Up a Solo or Small Firm Antitrust Practice. Big antitrust matters generally call for big teams of antitrust lawyers. So parties involved in high-stakes merger investigations and bet-the-company private litigation and class actions typically retain big law firms. Many, if not most, antitrust law section members began their careers in big law. A lot of them transition to government jobs, working at the FTC or DOJ. Others find a home in smaller law firms or academia. But there are a handful who strike out on their own in the middle of their career. Today, we'll be talking to an antitrust lawyer who left big antitrust law behind to work for himself. It's a relatable story for me and my co-host because we did the same. My co-host today is Matt Reynolds. Hi, Matt.
Hi, Alicia. How are you doing?
Great. Would you like to introduce our guest and kick off the conversation?
Absolutely. Sean Gates is a California-based antitrust litigator. After 20 years of practice at major law firms and a stint as a deputy assistant director at the FTC, he launched his own firm, which is now known as Illovsky, Gates & Calia, LLP. Sean is not only an antitrust specialist, but also a dyed-in-the-wool trial lawyer, having tried several antitrust cases, including some 40 and 50-day trials as counsel for both the government and for private parties. And I'd be remiss if I didn't also mention that Sean has been involved in the ABA antitrust section's leadership for many years. So welcome to the show, Sean.
Thank you, Matt. Thank you, Alicia. Thank you for having me on the show.
Absolutely. Well, I'd like to start our discussion today with sort of the big question of, what led you to go out on your own? I think a lot of our younger listeners in particular will look at your bio and say, wow, you had it all. Partner at a preeminent California law firm, stint in government clerkships. What led to that decision to strike out on your own?
Yeah, so Matt, I think that's a great question and a really important question for people to think about when they're going to start a small antitrust practice. So let me give you an answer in two parts. So first, I'll kind of tell my story, and second, offer a few insights from that. So as you mentioned, I'd been practicing for about 20 years. At the time I went out, I was the partner at Morrison & Foerster, based in Los Angeles. And, it's a great firm. I really can't say bad things about it. I had really good collegial partners. I enjoyed my work. I was in a good position. I was heavily involved in, kind of some of the firm administration things that I enjoyed. So why leave? Well, I actually spent about a year thinking about it. And, of course, there were the typical reasons. So, I love the craft of litigation, especially trial. So maybe going small would offer more opportunities. There's a draw of being your own boss, the idea of building a practice, kind of the entrepreneurial stuff. But for me in particular, this will be a little bit surprising. The decision was both theological and personal. So theological, you probably don't hear that too often, but, so in the Reformed Christian faith, there's this doctrine of vocation, doctrine of work, which deals with what gives work its worth, its value, and how you can serve God through your vocation. So I actually read a lot of books, talked to a lot of people, went to a conference on the doctrine, and then personal because I had to try to apply that learning, that doctrine to me in my situation with my skills, my disposition. So it was a kind of a long self-evaluation. And the question was, would starting my own firm allow me to better serve the purposes of work? So what, that's kind of unique. What kind of insights you have for people who are thinking about this? My first piece of advice is if you're thinking about starting your own firm, make sure you're not just running from something that you don't like. You know, a lot of people, I talk to a lot of people who are thinking about this, and I get the sense that many of them are just like, I need out. And it's probably not the best because, starting a small firm is not for the faint of heart, as you two know. And so there needs to be something more than just escaping. And I think that kind of a way to summarize it is philosophically, is starting that small firm going to allow you to lead a more beautiful life? So try to measure that life not simply by kind of what think it's good for you, but what's good for others as well. So that's my kind of philosophical advice for people who are thinking about this journey.
Yeah, I can definitely understand what drove you to do that. I agree. It's probably personal to everybody, but maybe the common thread, and was true in my case, is the time to go out on your own, or the reason to do it is at a point when you really do know yourself and what you want and your own definition of success. And I think that's what sort of made me comfortable with doing what I did. And I was about 19 years out when I left Big Law. Matthew, what do you think?
Yeah, I have to say, for me, I think I made the jump a little bit earlier in my career than both of you. I was 13 years out of law school and a counsel with McGuire Woods in Washington, D.C. Like Sean, I had a great relationship with my firm, really liked my colleagues, liked the work I was doing. For me, it was really a call from my best friend from law school, somewhat out of the blue. He had been solo for a couple of years. So when I started up, I did have the benefit of him having already set up some of the basic infrastructure, things like malpractice insurance, Westlaw, firm invoicing and time management software. But the conversations we had about that really were an evolving thing for me. To be candid, striking out on my own was not something that had been on my radar. I was perfectly happy with the position I had and the work I was doing. But I had a very persuasive good friend who is now my law partner. And over the course of several discussions and several months of consideration, talking with other friends about it, I decided to take the plunge. And I'm very happy that I did.
Alicia, I think you kind of hit the nail on the head when you said you got to really know yourself. That's perfect. Was the Temple of Apollo. There's the famous saying, "Know thyself," right? And that rings true today as it did then. That's the key. And
that's right.
You need to do that kind of self-evaluation.
Here's a question we had. I'm curious to know, what kind of practice did you envision at the time that you set up on your own, and how did it compare to the reality once you were up and running?
So I'd practiced antitrust for 20 years. That was kind of all I did, antitrust litigation. And as you said in the introduction, antitrust litigation's for the big firm, right? So I actually thought I was giving up antitrust. And I had prepared myself mentally to focus on small commercial matters. But happily, I was completely wrong. So now I'm doing about 50% antitrust litigation, the other part commercial matters, and and they haven't been small. They've been pretty significant matters. So I was very happily surprised that there are opportunities out there that I had not anticipated.
And can you give us a sense of sort of the types of matters you're handling?
Yeah, so my role kind of runs the gamut. So it'll be from something like, very small, representing a witness in a large MDL, to being co-counsel with a large firm handling an aspect of a case. And as an example, I helped in a 1-800-CONTACTS case against the Federal Trade Commission, and my old friend Greg Stone at Munger Tolles brought me in to just handle Google because they had a conflict with Google. So I did the Google piece of the case, and then I ended up, being part of the trial team, and it was fantastic. So I've had that experience several times where I'm taking a piece of the case. And then there are some matters where I'm actually just the lead antitrust counsel. I'm the guy. And, I had a case that kind of fell into my lap from a referral from a friend at a former firm, and ended up going to the California Supreme Court. So kind of runs the gamut. And, I'm willing to do anything, as I always say.
Well, that's a terrible law firm motto. We'll do anything. Now, obviously, word of mouth, in my experience, has been the primary and the best way to get the best work. What else have you done in terms of your marketing and business development?
Nothing.
Okay.
Yeah. So if you look at, you go out and you get the books and you read the blogs and everything, it's all focused on consumer-facing firms, website SEO and stuff. That's just not our audience. And so for me, it's almost 100% referral. Of course, you got the website up as kind of the online resume, if you will. So my marketing is really keeping in touch with friends and getting things out there so that I'm a little bit of top of mind.
Right. I do think having a credible, very professional, clean website is important from the very beginning. That shows and with an appeal to the corporate client, the business client that you want to attract. Do you agree, Matt?
Yeah, I think that's right. We spent a fair amount of time, a couple times in our life as a firm, putting together a website that we thought would be, a solid one, professional looking, lays out our credentials, our experience in a way that, appeals to clients. And frankly, given the area we're in, obviously, as we've discussed, we are a lot of times going head to head against much, much larger firms with very established reputations and decades, if not centuries, of experience. And so, having a website that looks every bit as professional as the websites of the other firms that your clients are using is a really important thing. And I do agree with Sean that, I think the website is in some ways sort of the most important calling card that you have. Our own firm hasn't really done much in the way of traditional marketing efforts beyond, as Sean said, staying in touch with friends and former colleagues, keeping in touch with them, keeping up with what people are doing, what they're working on, where they're going when people jump from one company to another or from one law firm to another, just keeping up with what's going on, because that is sometimes the best source for referral business.
Yeah, and Alicia, you're again 100% right about the website. So I had my old firm was Karis Lex PC, and just a few months ago, I joined up with a couple of my former partners from Big Law, and we formed this new firm. And I just spent the last couple months putting together the new website. So I put a lot of effort into that, and hopefully it turned out well.
Well, I know we talked a little bit at the beginning about the thought process that went into your decision to make the jump from Big Law to solo practice. But if we could also talk a little bit more concretely about what preparations you made to make that jump once you had come to the realization that it's what you wanted to do. Did you create a formal business plan, or what other steps did you take?
Yeah, I never created a formal business plan, but what I did do was try to figure out what is my value proposition. And it was, fairly straightforward. I've got 20 years of litigation experience at Big Law, and I'm going to, have lower rates. It wasn't that complicated. But as far as kind of more concrete preparations, I think the biggest hurdle for most people when they're thinking about this is, am I going to starve? And I thought about that too, of course. So for me, I basically squirreled away a whole lot of money, had that on hand. And then, I spent a lot of time trying to figure out, okay, what kind of technology do I need? What does insurance mean? What does, all the mechanics of it, and had that kind of all ready to go and at least knowledgeable about these areas before I launched.
Yeah, for me, one of the most important resources that I drew on was an article. I know this was 2012, so, it's back a ways. An article about another lawyer's paperless office. And I had been pretty efficient with the computer. I knew how to, store documents in folders and all of that. But this truly laid out in very good detail how exactly to create a paperless law office. And that has been hugely helpful. I can keep everything at my fingertips and operate very, very efficiently, which will, of course, make it easier to justify my low rates, as you say, Sean. That is the competitive advantage.
I had one other advantage, which was when I was at Morrison Foerster, we shared secretaries. And there was one partner who basically monopolized the secretary. I did not have a secretary for all intents and purposes. So I learned how to do everything myself. And that really paid off dividends when I went out on my own, because I wasn't having to scramble to find somebody to help me to do things on the computer or, set things up.
Do you think there's an ideal time or career stage to break away into solo practice from big law? Because I know people who've done it at lots of different stages. And of course, it's not uncommon, by the way, for folks after they officially retire from decades of practice in a large law firm to set themselves up with a consulting sort of practice or hang out their shingle. But we're talking about a little bit different. We're talking about the situation mid-career folks making this change. So as between the folks in their most active years, do you think there's a good time or a bad time?
Yeah, I think it's that point where you have enough experience under your belt to really have that value proposition. Antitrust law is not something you pick up, after 2 years or something like that. It takes, you need some experience. And if you're going to represent companies or individuals in antitrust cases, they have to know that you've got the background, the expertise, the skill set to represent them. So for me, it was 20 years. Matt, 13 years, obviously that's plenty of time. But that's the first thing, is the skill set. But the second, I think, is you need to be comfortable that you can handle everything yourself. Because you won't have, especially if you're going solo, you're not going to have a big team to back you up. You're not going to have people to call on to do all kinds of things. And you have to be comfortable in making substantive decisions on your own. So you have to be confident in that. And for me, having the 20 years and the stint at the FTC, I was at that point where it's like, yeah, I can handle this. I can handle a case.
So you mentioned before that initially when you left Morrison & Foerster, you were out on your own in a solo practice, and you mentioned that you recently joined back up with some former colleagues. Can you share with us some of the pros and cons, in your view, of going solo versus teaming up with other attorneys, since you've had some experience with both?
Yeah, I mean, the big draw to being solo on your own is you're on your own, you're your own boss, you can do everything the way that you think is best. And obviously, when you team up with other folks, then you need to be flexible and make compromises and things like that. So I think on your own, it's kind of good and bad, right? You're responsible for everything, and if that's something that you enjoy, then it's great. If that's something that terrifies you, it's no good at all. And then when you join up with others, so now I've got 5 other partners, and what's great about that is, they've done some antitrust. A few of them have done some antitrust, a couple of them quite a bit. But they also have other skill sets. For me, they do white collar work. They do, regulatory litigation, things I know nothing about. And so it's great not only to learn from them, but also to have that resource. So that's, one of the big things about even big law or just joining up with anybody is having that resource of other expertise. I think that's the biggest plus.
And how much of a factor do you think is geography? With Zoom, of course, these days, maybe it's less of a factor than it ever was before. Antitrust, at least here in the U.S., by its nature, because it's so heavily federal law based, you can easily have a national practice regardless of where you're sitting. Have you found that to be the case in your smaller practice setting?
Yeah, so most of my commercial work is California. Antitrust cases tend to be more spread out, more California-based or DC-based primarily. But the beautiful thing is, since the pandemic, it's much easier and much more thought of that location doesn't matter as much. Obviously it matters to where you are admitted to practice, I think that's the biggest thing. Obviously, you can go pro hack everywhere, but you need to get some good local counsel and such. But I think that post pandemic things have really opened up. And there's good and bad aspects of it. So I think geography is less important than it has been in the past.
And I mentioned Zoom, and I mentioned having a paperless office, which in my case has certainly reduced overhead, reduced the need to have real estate or file people or administrative help. How about other forms of law practice technology? Have you been using tools? How much do you rely on them?
Yeah, so I do everything is cloud-based. So all my documents are cloud-based. You've got to have a time management system, a billing system and all of that. And there are just great tools out there. They're very easy to use. You can learn them, in no time. So there's great practice management software out there. It's very, very easily doable.
Yeah, and cheap too.
Yeah, reasonable. Yes, absolutely.
Yeah, and if I can share, that was one of the biggest concerns I had when I was thinking about taking the plunge into joining up with my now partner. Thinking about, how would I do everything that I do now at a big law firm? How would I replicate all of that? And I must say that after a few months, I really found myself saying, wow, we really can do pretty much everything that we used to do. I think the proliferation in particular of discovery vendors also has really allowed those of us who are litigators, whether it's antitrust litigation or other sort of complex commercial litigation, to scale a team as we need it. Within the first year or two of our firm, we had a team of 20 plus contract attorneys doing a giant review for us and producing a document production of a size that I easily would have done at Sherman and Sterling or McGuire Woods. So I think having those third party vendors and even having those kinds of relationships with folks at those vendors really does help with the value proposition that Sean talked about. We really could take on a large case without having a huge number of full-time employees on the payroll, so to speak.
Yeah, I mean, one thing actually I learned back in my days in big law was, in particular, I was at Munger Tolles early in my career, and one thing I learned there is that small teams actually can handle big matters. You don't have to have 40 people on a team or 20 people on a team. If you have, 4 or 5 people who are dedicated to it, you can really do a big case. And so that was very helpful to me, thinking about going out and actually going out, because I can find a few other people to help me on cases, whether there's other small practitioners or whatever.
Yeah, the firm that I started with, which was then known as Bingham, Dana and Gould, an old, line Boston firm, had a tradition in its litigation area of very lean staffing. We were all being trained and brought up, all of us, to be first chair lawyers, sometimes where there was no other chair, that is at the trial. So most cases had maybe 3 lawyers, senior partner, junior partner, senior associate, and then maybe a junior associate, and maybe a paralegal to help out. I was kind of used to doing a lot with a particular matter and not having it be so atomized as I think it might be the practice these days.
I think we were going to talk next a little bit about the things that, and I think each of us can probably speak to this, the things that we would tell young lawyers are the best things about being a solo or being in a small firm. So I guess I'll ask Alicia, if you want to start, what are the things that you would share with young listeners about that?
Well, tying back to my theme of knowing myself, I really do like to have sort of hands-on control of everything I'm doing. I want it to meet my standards. I can often just sort of visualize how an outcome can be achieved, and I do see the way to get that good outcome. And while I was very, very happy, leading teams or being part of teams, it was getting to the point where a lot of the stuff I was doing, there were just things at the law firm that were getting between me and the client, or between me and the outcome that I wanted to get to, and just inefficiencies and unnecessary kinds of things. So since I had sort of the I'll call it confidence, not arrogance, confidence, to think of doing it sort of more efficiently and offering better value for the client, I realized there was just so much about the big firm I did not need and could do on my own. And best of all, and here's my number one thing, you get to keep all the money.
Well, Sean, can you share with us some variations on that theme of your own from your own experience?
Yeah, so my answers are actually very much similar to Alicia's. I think we're on the same page on a lot of things. So I am very hands-on. I too think in order to provide good value to the client, I need to know all the facts. I need to know, the ins and outs of the litigation so that I can, know best how to get to the right outcome. So the hands-on aspect is very, very important to me. And I think that's one of the best reasons that you can go out on your own. And that allows you, in my view at least, to offer better value. The one thing that people do often think about with smaller firms is that there's more flexibility. More flexibility to shape your practice, more flexibility to shape your life. And that's true up to a certain extent. I mean, if you're a litigator, the courts drive your life to a certain extent, and there's nothing you can do about that. They set the deadlines. But you can shape your practice and you can shape your life better. I think you have more control over that in a small firm.
Okay, now, Matt, your turn.
Yeah, well, I think I can share a couple of points that I think maybe are a little bit different from those that you've both expressed. And I think they have to do with the fact that I, as I mentioned, did take the plunge a little bit earlier on in my career than both of you did. I think one that really immediately comes to mind is client contact and client accountability. I was fortunate in both of my old firms to have a pretty substantial amount of client contact for an associate and then later as a counsel. But still, I felt like in the years since I've jumped out and been part of my current firm, it's nice having that feeling that these clients really are your clients. And they're clients that are looking to you and your partner and your team. You're the one who's getting the phone call. You're the one who's getting the email saying, we have something new. How do we deal with this? And it is nice having that sort of direct relationship. As I'm sure your experience may have been at your own large firms, a lot of times, especially when large firms have large institutional clients, the client relationship is complex, many layers, many connections between many different lawyers at the firm. And it's nice in some ways to have a simpler, more straightforward relationship with the clients that you're working for. And as for myself, another point I think is, and this is something I can speak to in particular in the last couple of years since we've grown a fair bit over these last 2 years, is being able to build a team that is truly your own. I've really enjoyed the fact that we have been fortunate enough to have a pipeline of work that has allowed us to grow. We're 10, soon to be 11 full-time lawyers now. And being able to craft that team, sort of build that family, has been something that I found to be very rewarding. One of the things that I think is very interesting is 3 of my colleagues were all law school classmates and friends with one another. So I thought that was kind of a neat thing. That doesn't happen so much, I guess, in my experience. When you go to the big firms, my classmates from law school, we all spread to all the different firms in New York and DC and California. And we were lucky if maybe 1 or 2 of our friends ended up at the same firm for some period of time. And now we have 3 good friends who are now working together every day virtually in the context of our firm. So I found that to be also a sort of a surprisingly rewarding aspect of running my own firm.
And Matt, I would echo you on the direct client contact. I mean, as a lawyer, what you want to do is serve the client and help solve their problems. And, it's very rewarding to have that direct client contact. You're the one talking to them, understanding them, helping them with the problems, as opposed to it coming through 3 levels above you.
Yep. Well, I can't agree more. Now, we've painted such a rosy picture of solo and small firm practice. It makes me wonder if there'll be a wave of resignations after bonus season is over. We'll see. We'll see. But that brings us now to our ending segments, where we try to get to know our guest a little bit more as a person, as opposed to a lawyer. So, Sean, can you tell us something interesting or surprising about yourself that is outside of your professional life?
So I have the privilege of working with adults with developmental disabilities through my church. We do camps. We have a Tuesday night program. We got a Sunday school. And it's not just me. It's actually my whole family, including my sons-in-law. I've roped them into it too. And it is, I say it's a privilege. It's just an absolute delight to be able to serve these folks. And like I said, it's now become kind of a family tradition.
Very nice. And before we let you go, we're also going to play a little game we call The Curious Hat.
And now it's time for The Curious Hat.
The rules of the game are extremely simple. I'll ask Matt to draw a random surprise question out of an entirely virtual hat. So take it away, Matt.
So, Sean, your Curious Hat question for today is, do you like to cook? And if so, what is your specialty dish?
I can't cook. I'm absolute, completely useless in the kitchen. When I was a bachelor, my wife laughs at me because it was like, Marie Callender's frozen dinners and things like that. The only dish I was ever kind of semi-capable of producing that had any kind of nutritional value was a nice, good spaghetti with a red meat sauce. That's about it.
Well, that's pretty good. That'll keep you alive for pretty long.
It was a few years.
Thank you, Sean, and thank you, Matt. This was a great conversation. So thank you both, and thank you to our listeners. Tune in for next week's Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.